Since I started this in this office, which has been about 2.5 years, there have been about 35 changes in the documents. This time we have the most recent set of documents, and I have added several for those of you who've come before. We now have probate listings and probate purchase contracts. We have 1031 exchange because we're beginning to see some 1031 activity. So this will be a kind of beginning to end, soup to nuts. If you can think of something I've left out, tell me and I'll add it next time, and you'll have to stay an extra 5 minutes. I like the preamble, not just because I wrote it many years ago, but because I've never found a better description of why we really need to know our business. There's no best way to be a real estate practitioner, but there are many good ways. Fundamental to any of those good ways is a strict adherence to law and ethics and to the affirmative duties imposed by law and the Commissioner's regulations. No greater demonstration of duties faithfully performed is available in the courts of law or the court of public opinion than a diligently, accurately, and unambiguously completed set of contract documents. It's owed to the client, and it is the first line of defense in risk management for broker and agent alike. That's really what we're about, is trying to do this stuff. So, grab tab number 1 and open it up. For those of you who are relatively new to the game, you probably wonder why we make all this fuss about agency in California. We do. We make quite a stir. We have all this stuff that we have to do and say about agency, and it's reams of paper, and we have to do an AD form times 3 times and all that sort of stuff. Well, the reason for it is this. We have a fiduciary relationship, and part of that fiduciary relationship is to say who is representing whom and confirm that. Because up until 1988, and many people in the business don't know it, up until 1988, buyers were not represented at all in real estate in the United States. The agent who wrote the purchase contract was a sub-agent of the seller and had an affirmative duty to raise the price as much as he could. And we were specifically prohibited, when I got in the business 30 years ago, from showing a buyer comps that would suggest that the property could be sold or could be negotiated for less than the asking price. In 1982, the Federal Trade Commission took a look at it and said, this is terrible. 80% of buyers surveyed thought they were being represented. And the notion that a buyer was unrepresented, and always had been, just ground down. Well, one of my questions that some of you have heard, and I think that's important, is how long has agency been around? And where was the first test case on agency decided in a court? Well, most people say, oh, 1950, and California's always been out there pushing. The reality is that the date was 1306. And the place was England. And they said, the squire, who has a servant called a steward, who has a servant called a servant, are in line, squire, steward, servant, and the servant paid by the steward is the sub-agent of the squire. And the townspeople who gave the servant a small token for negotiating the sale of sheep were not entitled to be represented, and he was not entitled to take their money, because it was the squire's money passing through the steward to the servant. And we followed that model in real estate. The seller gave money to the listing agent, who gave it to the buyer's agent, therefore creating a sub-agency. The Federal Trade Commission had a wonderful answer. Somebody trying to get in?
They wanted out the door.
Okay, the Federal Trade Commission said, well, this is easy, we'll just set it up. No real estate brokerage can sell its own listings. You can sell the other brokerage's listings, they can come sell yours. That way we'll solve the problem. And the state of California looked at it and said, well, we don't see how it solves the problem, because the money still flows from the seller to the listing agent to the buyer's agent. And by the way, When we use the term selling agent, we mean buyer's agent, and when we talk about listing agent, we mean seller's agent. How do we get so upside down? I don't know. So I will talk about listing agent and seller's agent interchangeably. I will talk about buyer's agent and selling agent interchangeably. I hope I don't confuse you. And the state took a look at it and said, well, this is stupid. The buyer should be represented. And they created the California Laws of Agency, which took 680 years of history and custom of the business, and just, the common law, just threw it aside and said, this is how we're going to do it from now on. But there's this huge caveat. We are changing the common law. There are 49 other states that don't look at it this way. Everybody's entitled to know who is doing what to whom. Otherwise, this will not stand a court test. And so we created a three-legged stool, if you will, for agency. The first is the disclosure, the AD, which we'll talk about here in a minute. Then we created a place, and it used to be buried back in paragraph 28 in the purchase agreement, that said this is how agency is designated in this contract. And then on page 8, we designated something else that said, we agree that everything we said in here about agency is true, and that must be signed. We'll come to that as we go past the course. The important thing was that the state of California, somebody said, it doesn't matter who picks up the tab, the buyer is entitled to representation. And son of a gun, that has never been contested. And now I think all but 2 or 3 states follow that model. We no longer have sub-agency. It is specifically written out of real estate law in California. There is no sub-agency anymore for you to contend with. You do not have any duty to the seller, if you represent a buyer, more than honesty, fair dealing, and full disclosure. You are not obligated to get the seller the highest price. You're obligated now to get the buyer the lowest price. Does that make a kind of sense? Mm-hmm. And when they finally got to looking at it and scratching their heads, they said, well, it really isn't the seller's money to begin with. The buyer is putting the money in, and some portion of that is going to pass to the real estate broker. Everybody knows that. So if the seller wants to go out and sell his house on his own without a real estate agent, it is indeed probably all his money, but the buyer is bringing money in that contemplates the inclusion of a brokerage fee, and it's the buyer's money passing to the seller, passing to the listing agent, passing to the selling agent, and sub-agency no longer exists. Well, we scratched our heads about it a lot and worried about it a lot, and we're fearful of what would happen, but it has worked out surprisingly well, if you think about it. Doesn't fairness suggest that somebody's going to invest nowadays $250,000 or $500,000 ought to have somebody who's on his side, not on the side of the guy who's trying to jack the price up? Of course. It makes just as good sense now as it did then. It made perfectly good sense then, we just had never recognized it as such. So now we come to the next page, which is the disclosure regarding real estate agency relationships. A few thoughts on that topic. The first is, if you have a member of the public sign a document, whether it is an application to rent or lease, whether it is a buyer-broker agreement, a property management agreement, a lease listing, a purchase contract, any document that's put up in the course of any aspect of real estate and signed by a member of the public, you must provide this to them, absolutely by law if it is 1 to 4 units, and by custom and good standards of practice with anything else. I require my agents to get this signed if they're doing, and we do them, $1.5 million commercial buildings. I want people to know how agency works, because it works exactly the same in everything that we do. Let's take a look at these interesting things. We have seller's agents, we have buyer's agents, and we have agent representing both sellers and buyers. The crucial language here is the fiduciary duty. And I'm going to go back, you have to turn the page back, but I'm going to read a quotation. Fiduciary responsibility is the highest duty in the civil law. That was said over 230 years ago by William Blackstone, who was a famous commentator on the English common law. It remains true today. the fiduciary responsibility is not anything except 100%. You don't have some fiduciary responsibility. Either you're a fiduciary or you're not. If you are, it's 100%. And here's what a fiduciary responsibility is. And this applies to both buyer's agent and seller's agent. A fiduciary duty of utmost care, integrity, honesty, and loyalty in dealings with the seller, or in the case of the buyer's paragraph, in dealing with the buyer. And to both parties, diligent exercise of reasonable skill and care in the performance of the agent's duties. How long have you had your license?
3 years.
Okay. Do you think you have the same standard of care that I do after 30?
No.
Reasonable care, a reasonable standard of care. Look how many things I've looked at, just in my own. And then every time one of my colleagues has an experience, I have that experience too. My standard of care is enormous. Yours is much greater than it was if your license had been 3 months old, but it is nowhere near what mine would be. So when they say reasonable skill, that's what they mean. You're not going to be perfect, God knows. Understand, we call it errors and omissions insurance because we err and we omit. And you are going to blunder mightily in the course of your career. There's no way around it. We have offered too many opportunities. Here's the second thing, owed to each principle. A duty of honest and fair dealing and good faith. Do you have a good moral compass? This will not be an issue for you. Do you sometimes wonder if white might be, or black might be a little bit gray? Then you better tighten up and listen up and do this. And then finally, a duty to disclose all facts known to the agent materially affecting the value or desirability of the property that are not known to or within the diligent attention and observation of the parties. An agent is not obligated to reveal to either party any confidential information obtained from the other party that does not involve the affirmative duties set forth above. You say, look, we don't want to talk about we're listing the property because we're getting divorced. Is it okay if I tell the other party? Maybe, but maybe I could have a piece of paper to say, hey, you probably get some more action if you put down divorce forces sale. But I better not do it without you and your soon-to-be ex-husband or ex-wife saying so. Do I have any obligation to tell the buyer's agent when they come along that the divorce forces sale? Absolutely not. Absolutely not. There is one little anomaly that we put in dual agency. In dual agency, which I like, you can handle it, you trust the agent on the other side. I mean, after all, if it isn't you, they sit at the next desk. But the thing I like about it is this. You know for a certainty that both parties hear the same thing. The only thing that you may not do in dual agency that you are obligated to do in single agency is disclose to the buyer that the seller will take a lower price or disclose to the seller that the buyer will pay a higher price. Everything else is exactly the same. If you are making an offer on a Century 21 property and the Century 21 agent says, look, give it your best shot, but I do know that my buyers will come down a little. And you say, oh, well, that's nice. No, you have to go back and say, hey, Joe, Harry, this guy just violated his fiduciary responsibility and told me his seller will take less money. You're obligated, I'm obligated to tell you that. You're entitled to make some accommodation. Maybe we should offer a little less. Should we rewrite page 1? The same as the reverse. If you say, look, this is low ball. I'm sorry, Joe, but it's the best I could do, but I know they'll come up some. He has an affirmative duty when he takes that and says, okay, there's more money there. Let's drive the truck through when we get a counteroffer. You have to do that if you're a single agent. In dual agency, it's presumed, I'm the selling agent, you're the listing agent, it's presumed that we know. I know your seller will take my net less money. You know my buyer will give more money. That is a presumption. Because theoretically, a dual agent could be one person. And you know that that's in your head. They said they pay more, they said they pay less. You cannot discuss that. Otherwise, agency is very simple. And the nice part about agency, which I'll give you in some detail as we get to it, is this business of everybody hearing the same thing. You want a quick illustration of something like that in dual agency, or do you want to go on?
Go ahead.
We can go on.
Okay, well, you want to go ahead, you want to go on. Deposit, earnest money deposit. The law says that if the liquidated damages are initial, we'll get to liquidated damages, that the seller can get no more than 3% of the value of the purchase price, or the deposit, whichever is less, in the event that the buyer really defaults and is at fault in the cancellation of the escrow. My example, the loan docs are signed, the buyer's money is in, the thing is ready to record tomorrow, and they say, stop, we don't want to do this. Open and shut case. But the most that the seller can get is 3% in that case. But is it customary to give a 3% deposit? Very seldom. Okay, you're a dual agent, you have the listing. And we're going to make life easy. It isn't my listing, you because we both work for the same Pioneer. It's your listing. And you've already told them, hey, look, there's a chance somebody may come and ask me to sell this for them, buy this for them. And I want you to understand, I will be very fair and take care of it. You get the people in, they really want to buy the house. They seem qualified. And you sit with them, okay, this is something that you're going to need to understand, because it's just a little bit different than if you had a Century 21 or a RE/MAX agent. The first issue that comes up out of dual agency is going to be this business of the deposit. I've explained to you that the seller can get 3% if there's 3% worth of money in there, or the deposit, whichever is less. It is customary not to put 3% in, 1.5%, 2%. That's customary. Now, you decide what you want to do. 1.5%, yes, good, that'll be fine. Now you understand, because I'm a dual agent, I'm going to go over to the seller when we get your offer written, and I'm going to say, Mr. and Mrs. Seller, as we discussed earlier, the deposit can be anything that the buyer offers and that you accept, and that you can only get 3% of it, or the amount, whichever is less. These people, very good buyers, well qualified, have offered you 1.5%. I'm going to tell the seller that because that's my duty. And I will say to the seller, you have the right to make a counteroffer that says, among other things, I want 3% or I want 2%. Or you can just accept it and we'll go on to the next point. If you go back, if you make a change, if you say I want 2% or 3%, I have to go back to them, and what I will tell them is, you have the right to accept this, make a counteroffer to it, or reject it and walk away. Come back to the buyer, he asks for 2%, and we go through that routine. Both sides have heard exactly the same thing, but the decision has to be theirs anyway. It should be. If somebody comes in and says, what should I give as a deposit? You say, oh, well, let's give 1.5%. Should explain it to them even if you're a single agent. So what you have in dual agency is simply the necessity to tell the story to one party and then say, I'm going to tell this story to the other party, and these are the terms I'm going to use. You go to the other party and say, I told the other party, the first party, the buyer, this story, and I'm telling you this story, and when I go back to them, this is what I'm going to say. And you perform dual agency, and you have everybody in agreement on everything as you go along. The supreme dual agency coup is when you get buyer on one side of the table and seller on the other, and they negotiate what it is you're going to write down. I've had that happen 2 or 3 times in my career. Just sat there, they knew the property, they knew what they had. Here, Norm, write this. Interesting. Now, we came along, legislators do strange things. We had the requirement that what is now called Form AD1 be presented to, explained to, and signed by the seller at the time of listing. Form A, what is now called AD2, was presented to, signed by, well, stranger in paradise.
Hello?
We had a little glitch at the front end here. The dates on the table of contents are wrong, so if you just rip out the table of contents and change it,
Okay.
it'll work fine. It's a whole new.
Thanks.
Anyway, the buyer has this form AD, now AD2, presented, explained, and signed. And sometimes I find people who are not aware of this. You may not, as the listing agent, present an offer to your buyer unless the form AD accompanies it. Aha! Every now and again I see, oh my God. Do we do that? All the time. It's against the law. No Form AD signed by the buyer, you can't present to the seller. Well, we finally got used to that. You have the book. Good, come in.
Okay.
And the only thing you have to do is to change the table of contents,
Okay.
which is about page 4. And you would think that that would be sufficient, or if the buyer's Form AD was to be passed to the seller, you'd think that the seller's AD could be passed back to the buyer through the listing agent and the selling agent. But the legislator said, no, agency is so delicate that after 20 years of doing it that way, they said, we need a third one. The selling agent, the agent representing the buyer, must create a Form AD, now called AD3, with the selling agents, the buyer's agent's brokerage name on there, and pass that through the listing agent and have it signed by the seller and returned. So if you're not a dual agent, at the close of escrow, you should have a copy of 3 ADs in your file. Is that a clever way to do it? No. It just adds another piece of paper and loads of fun. Then there's a little summary back here. Turn over the 2 pages. It says agency disclosure, CNR form, the 3 disclosures rule. Stated another way, the listing agent creates 1 agency disclosure, the selling agent creates 2. Now, if you're in a dual agency situation, you only need 1 from each party, because it is presumed, even if you're selling one of Rose's listings out of the Claremont office, that you are the same person, because you are both a dual agent and we have all that we need. Is that fun? Does this business make any sense at all?
So when you're a dual agent, you don't need
You don't need AD3.
the one that says you're representing both sides?
No, that's not, the disclosure doesn't say anything about who represents who.
Okay, what I'm asking is, do you need these 2 plus the one that says you're representing both sides?
That's not an AD, we're talking about the agency disclosure only. The agency disclosure form simply says this is how agency works in California. It doesn't say who is responsible, who is representing whom. It simply says, here's a piece of paper, if we ever get into business and you start to transact, you're entitled to know how agency works. This does not assign the agency relationship in any way, shape, or form. What you must do is demonstrate that all parties have been advised of how agency works. That's the whole purpose of the agency disclosure, and that's why we go overboard about it. If you are single agents, the listing agent does one with the seller. The seller's agent or buyer's agent, selling agent or buyer's agent, depending on how you want to phrase it, must have one with the buyer at the time that the contract is written, and in the course of escrow must create one that is signed on behalf of the selling brokerage, the buyer's brokerage, signed by the seller. So listing agent creates 1, selling agent creates 2. That's how we make money. Okay, let's turn over to say licensee's guide to required disclosures. I think I mentioned at the beginning that there are some additional things in here, and certainly we have added forms and we have added processes since I began doing this about 12 years ago. One of the things that we have decided in this era, where a lot of people look like me, old and wrinkled and ready to kick the bucket, is that there's a lot of trust work and a lot of probate work around, and we better understand it. So the legislature took a look at things and said, well, anybody who's selling a house who is a person, or an entity that is not a trust, a bank that took the property by foreclosure or deed in lieu of foreclosure, or a probate where somebody has died or been adjudicated incompetent, is required to provide all of these disclosures. And we make exceptions for trust, bank-owned, probate, because in theory at least, nobody knows anything. They're faceless people sitting in office buildings who are just administering this and know nothing of the property. Whereas a seller, whether it's in short pay or general, what we have now come to call a standard sale, know everything and they have to make these disclosures, and they are bound to certain other things, certain certifications. If you take a look at this, you'll see that with the exception of the form SSIA, which I seem to have put in twice, that short pay and standard sale have identical disclosure requirements. And you don't escape disclosing just because you're an investor and never lived in the property, or because you are a corporation that bought the property 5 years ago and has been leasing it. If it is not sold as a trust, an REO, or a probate, the disclosures all apply. Take a look at a couple of things that are interesting. The first one is that the smoke detector is required of bank-owned properties, but not of trusts or probates. And we'll talk about how you handle that if you're listing a trust or a probate. The result has been that we finally got our heads together and made one form for water heater strapping and smoke detectors, and then the people who were not obligated to certify smoke detectors wanted us to go back and have one piece of paper for water heaters. So you have two. We'll talk about that. Another brilliant stroke. And then look up here. The people who are not required to disclose are not required to provide a natural hazard disclosure. How many of you have seen a full-blown natural hazard disclosure, about 65 pages?
Mm-hmm.
Page 1 has 6 questions which are answered. That's the natural hazard part. All the rest is man-made. Taxes, Mello-Roos, 1915 Bond Act. The whole bit, all the rest of that is a disclosure. That is what these people are not required to provide. What they are required to provide is a disclosure of actual hazards. And guess what? Those are iterated in the trust document, the probate document, the REO document, and they're exactly the same 6. So most of the time, even an REO will be persuaded to provide a professional natural hazard disclosure, and that contains many things that are required disclosures for the buyer. Again, Mello-Roos, 1915 Bond Act, tax, blah, 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 blah. We'll get to that. We'll even have real ones to look at. So if you are listing, you probably won't list REOs. We've tried since 2004 in our offices to list REOs. One guy's been successful, the rest of them just finally gave up. But if you're doing a trust, an REO, or a probate, you'll probably be able to talk them into a professional natural hazard disclosure. And that takes care of a whole host of things that are required to be disclosed. So it's important to have it. There is a CAR form, which we will discuss, that's called the Natural Hazard Disclosure, an NHD. Do not use that. You're required to have it in your file by, again, statute. But don't rely on it. It may not be reliable. We'll talk about it when we actually get to the form. Turn a page, short sale information and advisory. Those of you who have been here in business a long time know that we are required to make certain disclosures as a result of statute or the Commissioner's regulations. This is something that must be made in the case of a short sale, and it is foisted on us by neither statute nor the Commissioner, but by the courts. I think I related the story of a Northern California agent who listed a property for $1.9 million, got a buyer right away. The buyer went home, sold his house for $680,000, arranged the loan for the rest, brought the money over, and it turned out that the liens against the property were $2.4 million. Nobody had bothered to disclose that this was a short pay and that this might not work. Well, the fellow was a little upset because he had $680,000 for a house, but he didn't have a house. And he had intended to buy this house and he didn't have this house. So he went to court and he sued everybody, and needless to say, he won. The interesting thing that came out of it is not just the language here, but the fact that, number one, it is the buyer's agent, the selling agent, who has the burden to demonstrate that the thing is or is not a short sale. Now, if you're not the listing agent and you're coming from another county, I'm not quite sure how you do it. So maybe one of the things you ask on something where you've pulled a profile and there's 300,000 owed on it and it's on the market for 210 is this a short sale? It doesn't say so. The other thing that has come out of it is a recognition by CAR that they cannot put their head in the sand and pretend that this is anything but a really difficult process. And here are the pages that iterate for both seller and buyer. This is something that you want to have signed by both seller and buyer, whichever side you're on, in your file, because this, kind of like the agency agreement, doesn't say you're going to get this short sale or you have to sell short sale. What it says is if you get into a short sale arrangement, whether you are the lister, the seller, or the buyer, here's what can happen. And there's no promises that any of it will. And each of these items in here is something that comes up, and most of you will recognize it. And it is placed on us by a decision of the California Court of Appeals. And I will not allow a short sale file to close without this document being signed by both buyer and seller. We'll go as we pass through some of these advisories, some of the disclosures. The SBSA, I don't really care if the seller signs it. If they just flat out refuse to sign it, I want it signed by the buyer. Because I want the buyer to know, if they're coming from Ohio, what a crazy place California is. Here's 10 pages with 35 items, including the fact that golf balls hurt if they hit you, and we need that signed by the buyer. Okay? Works. So take a look at this. Right at the beginning, what is a short sale? Well, we know what it is, but here's a wonderful description. Are you new, a rookie, never sold anything before, heard about short sales? You come in and sit down the first day. Aunt Maud calls up and says, I'm sorry, Sonny, I know I love you, and if you give me a good commission break, I'll list my short sale with you. And you know, oh my God, what's a short sale? Well, if you read this thoughtfully, it's amazing what a lucid description it is. It's remarkable. And the thing I like about it is it doesn't pull any punches. It talks about alternatives to a short sale, and I think they tripped themselves up here. This is paragraph 2. A loan modification. It goes on, very unsuccessful, and there are not many of them, but it has happened. A foreclosure. We know that that's an alternative to short sale. Sometimes it's the only alternative. You just can't get anybody to budge, and we go to foreclosure. That is certainly an alternative to short sale. A deed in lieu of foreclosure. That means, dear bank, here's a grant deed from me to you, and here are the keys, goodbye. Most banks won't accept it. Those that do, it goes on your record with the same impact on your credit history as does the ordinary foreclosure. Here's one that is not an alternative to short sale, and I think that CAR erred in putting this in here. They say that bankruptcy is an alternative to short sale. Bankruptcy is a means of stalling foreclosure. It is also a means of forestalling short sale, because while it is in the bankruptcy court, no lender will look at the notion of forgiving some portion of it. Most agents will not allow their buyers to submit offers on things in bankruptcy. How long does bankruptcy take? I don't know. How long is a piece of string? It's one of these things you simply cannot predict. We've had bankruptcies sail through in 6 weeks. We've had bankruptcies that we're still banging on the door 6 months later. If you are explaining this to a seller and they say, oh boy, this is easy, I'll file bankruptcy, all that does is slow the process down. It does not remove the prospect of foreclosure. The lender agreement to short sale. And then down here, a couple of lines. Prior to granting approval of the sale, the lender may require the borrower to disclose all of the borrower's assets. They may require that the borrower liquidate other assets. They may require that the borrower sign an agreement to repay some or all of the debt at some time. They may require that the borrower secure an unpaid debt with other assets owned by the borrower. Well, that doesn't apply, of course, if it's if it's the seller's principal residence, but we're seeing, believe it or not, we're seeing income properties going through short sale, and they're not requiring any further thing, no recourse, etc. So, you know, it's a movable feast. Seller's continuing liability on the debt. Some refer to continuing liability as a deficiency judgment. Generally speaking, a deficiency judgment is the right of the lender to pursue the borrower for the difference between the amount that the lender receives and the amount the borrower owes on the debt. Deficiency judgments in California are prohibited in certain circumstances. Well, we now have it set up so that if it is your principal residence, which it is for most people, that you are, once the lenders have agreed to short sale, you are then thenceforth free from any kind of judgment, or they're seeking any judgment, or they're seeking more money. They can't get a deficiency judgment, they can't make you sign a note. They don't have to agree to the short sale, but most banks are doing it, even second trust deed holders. So if you are in a principal residence, and that's the thing you're short selling, pretty much that is what you're gonna be up against. In these situations, whether the lender retains the right to pursue a deficiency judgment following a short sale becomes a negotiable term for each sale. How many of you negotiate your own short sales? Or do we have a negotiator here? Do we have a negotiator in the office?
There's some.
Yeah,
there's
there
some
is,
there.
there is one, yes.
Yeah, okay, do you use her?
No.
She's
No.
pretty good. She's expensive.
Summer.
Yeah.
Huh?
Summer and her mother.
Yeah. Well, Summer shouldn't be doing that, Summer's a license.
She's, no, the other lady.
That's
Her
It's her
mother.
mother.
Yeah.
You have to be a licensed,
Right,
you have to be a
yeah.
licensee to negotiate now. You don't have to be licensed to be an escrow officer. Anyway,
Helen.
Helen,
That's right, yeah.
come on, Mike. Better a dozen times, Kevin.
So, are we allowed to do it on our own then, if you have to?
Well, absolutely, you're
Oh,
licensed.
cause you, I thought you said a licensed negotiator.
No, you must be a licensee to negotiate.
Oh, okay.
And I like that because it keeps the bums out, for one thing. And it also means that, you know, if you do something, off with your head. And when you hire somebody on the outside, be sure that they are a broker, not a clerk working for a broker. You want the broker's signature on everything that's done. I like doing it inside for two reasons. One is you develop a relationship. Who are the people we deal with for the most part? B of A, Chase, Wells, some of the others, but those are the big three. And if you start getting to know the system, if you're using Equator, if you're warm and comfortable with one or two negotiators, you'll be able to do things that you might not otherwise be able to do. Now, if you have a book of business where you're closing 10 escrows a month, don't bother. Just pass it off to somebody, pay the $500, $600, $700, and smile from ear to ear, because you've got problems we'd all love to have. But if you are doing it, one of the things that you must be cautious of is that there is no caveat, no, but we can come back after you because we're not removing this, if you're doing somebody's income property. 2 units. They're not obligated. 3 units, they're not obligated to give this unless you negotiate it away. It's particularly true of second trust deeds where they're not going to get anything if it forecloses, so they want to get as much as they can up front. They even modified this, time goes so fast, it was probably October, November. B of A finally just turned over and said, okay, we can give $3,000 out of what we have agreed to the second trust deed holder, and we will allow the buyer to bring more money and give it to the second trust deed holder if the second trust deed holder demands it. And so everybody kind of fell in line. Up till then, it was not the way you did it. If it was $7,000 more, that $7,000 went to the first trust deed holder. But they weren't getting their short sales through, and they were having to foreclose. And so finally they came up with a sort of working arrangement. And if you have a buyer who really wants that house, and they want to bring in cash, and they want it to go off to the second trust deed holder before the close of escrow, it's legal. It's scary as hell. If I were a buyer, and I put $7,000 in cashier's check in a little envelope, and I mailed it to some outfit in Seattle that held a second trust deed, and prayed that 3 days from now this escrow would close and I would own the house, I'd have a few sleepless nights, I think. Get a written agreement about that. Credit, all of this will affect credit. It is interesting that short pay appears to affect credit less than foreclosure. And that even has the stamp, the imprimatur of the federal government, because Fannie and Freddie and even FHA say, if you allow a bank to foreclose and don't make any attempt, it will be 5 years before you can get a federally insured loan. Fannie, Freddie, FHA. If, on the other hand, you permit and there is a successful short sale, you may be able to get that loan in as little as 2 years. Interesting also, the greatest impact on a credit report, even with short selling without foreclosure, seems to be the number of missed payments. Somebody who misses 4 payments and has a short sale will probably wind up with a better credit rating than somebody who has 20 missed payments and a short sale, because each missed payment drags down the FICO score. Here's one that you better raise a red flag if you haven't heard it, or if you've heard it and forgotten it. We have no assurance that the federal government or the state of California will extend a tax forgiveness law that expires midnight, the 31st of December. If you have a short sale or a foreclosure and you don't close it by that time, you may have tax liability as ordinary income for the amount that is forgiven. That was always the case before 2007, and it will be the case, unless the law is extended, after December of this year. What does that say? Well, if you're in a 20% tax bracket and you have a $400,000 house that is just sold for $300,000, the amount forgiven is $100,000, you're going to owe $20,000 to Uncle Sam, because it's considered income in the year in which that forgiveness took place. Force your people who are sitting on the fence, well, we're going to try and negotiate the loan. We can't decide, the market may turn on. Okay, just look at this. Right now, the market says your house is worth $220,000. You owe $420,000. If you do not get it sold and closed by the 31st of December, and you're in the 20% tax bracket, you're going to owe $40,000 in income tax. Let's get on with it. Keep it in mind.
So
Here's-
can we market that?
What's the truth?
Cool.
There's something else too with the MIP that can't be written off anymore, right?
That's right.
Okay.
Yeah, more and more things can't be.
That's a
written
done
off.
deal, right? That's done. It's
That's
not going
going
back. It's
back.
not debated. It's on the table.
Well, no, I don't know. What day
Well,
is it?
right.
Who's
Right.
in cards, yeah.
Right.
Choose a number from 1 to 10. Okay, I'm very partial to paragraph 6 here, because I think CAR took a deep breath, looked the other way, and allowed it to be written. It is an unfortunate reality that many persons, including real estate licensees, mortgage lenders, and attorneys, among others, have taken advantage of owners of underwater or distressed properties. Some of the schemes present present themselves as rescues of the homeowner, promising to let them stay in the property to protect, etc., etc. That phrase, including licensees, was the first time that you ever heard CAR said, we have some bad apples. And they said it right here in writing, and you're going to get people initially. You just don't want to be a bad apple. Some of the red flags are people without a license. Do you deal with people without licenses? We see them popping up all over the place. Unlicensed assistants. One of the 3 litigations Lance has going now was negotiated entirely on the other side by an unlicensed assistant. We're not. Short sale negotiation, upfront fees, strictly forbidden. Surcharges, third-party negotiations, flipping, straw buyers. Broker role. A real estate broker can not give legal or tax advice in connection with any of the options available to a borrower, nor can the broker suggest what is the best course of action. Unfortunately, the owner is faced with extremely difficult choices, having a lasting impact on the owner. Owners are strongly cautioned that they must seek legal and tax advice in what is not only a choice impacting taxes and credit, but also personal issues affecting the owner and often the owner's family. Can we tell them the tax law ends on December 31st? Yes, of course, because that's public knowledge. Does he, you say, you sold your house, you lived into it in the last 5 years, Mr. and Mrs. Seller, you get $500 $500,000 relief of capital gains. You can say that, it's the public, you're not saying you should sell. You're not saying do get into a short sale. Say if you don't get into a short sale, that expires unless it's renewed. You can say anything that's in the public domain. We know what the rules are, the IRS rules are for 1031 exchanges. We can tell people that. That doesn't say a 1031 is good for you or a 1031 is bad for you. There's no sin in selling out at a profit and paying your taxes. I mean, that's perfectly legitimate. You know, I love paying taxes. I had 2 years in my life where I didn't pay any taxes. Damn, I was poor. More taxes I pay, the happier I am. Means I'm making money. You think about it. There's no sin in paying taxes. The sin is in not knowing the options. And our sin, our unforgivable sin, is in not providing the information that allows people to make sensible decisions or go to their professionals and ask sensible questions of the tax and legal professional. Let's turn over here, the Federal Trade Commission, Mars forms, and the current rule in view. Most of you saw Mars forms early last year. Do you remember them? Vaguely. Shelley said, CR says we don't have to use them. You don't use them. I require them. Because it said, the law said, that anybody who engages in loan modification, and what are we doing when we get a short pay? We modify a loan, right? But it is subject to these rules. And after it had been in effect for 2 months, in March of last year, the FTC got hold of NAR and said, hey, your people are supposed to be following these rules, and you have to provide these 2 forms. And then NAR, CAR, and a couple of the other big state governments jumped on them and beat them up, and they finally said, well, there's no guarantee that forbearance will continue. They said, we will forbear, which means for the time being, or at least for some period of time, we won't enforce the law. It is the law, you're obligated to do it. If you're not doing it, you're breaking it, but we won't enforce it against you. In most circumstances. Would anyone care to describe on the witness stand what most circumstances mean? Coming from a federal agency that changed its mind twice? I require Mars forms on short pay. How does it hurt? You know what we're beginning to see, and this is something that really gravels most of my fellow brokers, we're beginning to see banks approving short pay saying, and this language will be read to and signed by the seller. And what is it? It's Mars 1 and Mars 2. Why not just get it done up front, and that way you don't have any qualms, any obligations. That's, as far as I'm concerned, a personal choice because this office doesn't require it at this point. Probably Lance and Paul and Sheila and I, who are the remaining management staff, will have some kind of a discussion of this. Because I think that the farther we go into short pay and the farther we go, the more illegalities are going to occur. We're already having people arrested for issues that came to light as recently as last autumn. There are always going to be bad apples. And if you don't want to be regarded as a bad apple, say, well, at least I went through the form. I may be a bad guy, but I told him I was going to be a bad guy, or whatever it is you're going to do. Anyway, here are 2 of them. Mortgage Assistant Relief Services. Look them up, think about them. How would it impact you? How gravely would it affect you to have them sign one more document at the time the listing is taken and one more document before you present the offer that their payment is made? I told you we're going to do trusts this time. A trust can be in many forms, and there are 2 that most frequently arise as a seller in a real estate transaction. A revocable trust, the original trustees, or one of them at least, is alive. And an irrevocable trust in which the original trustees are dead and the responsibility is passed to a successor trustee who cannot change the trust. Most trusts contain a will. You can't imagine if you were an executor or an administrator of a will going and saying, well, I don't like the way they wrote this will, we'll just change that. Same thing applies to a successor trustee. The thing that you must remember, because most people are not familiar with it till they run it a time or two, is that the trust is the seller. The estate of so-and-so in a probate is the seller. The trustee isn't the seller. The trust is the seller. If any of you have ever done business with a corporation, you'll say General Motors Acceptance Corporation by Joe Jones, Vice President. Okay, think of the trust as being General Motors Acceptance Corporation. The Anna and George Jones Trust by Fred Smith, trustee. Most of the time, you will find that trustees, even attorneys, will give you as full a disclosure as possible. They'll certainly do an NHD. Most of them will provide a home protection plan. Most of them are very anxious, if they are well advised and are children of the original trustees, you'll find that they're willing to give some kind of disclosures. We have a thing now, they're specifically not required to do a TDS, Transfer Disclosure Statement. There is no prohibition upon their doing a seller property questionnaire. And we ask on trusts, we ask on probate, that a seller property questionnaire be prepared. And the courts have not had an appellate ruling on it, but they have talked about in court, well, Mr. Jones, you were your mother's caregiver for the last 8 years of her life. You lived 2 blocks away. You've signed many of the work orders and you wrote the checks to pay the, isn't there something about the property that you as an individual involved in it ought not to disclose for the good of your soul and the good of the buyer? Now, if it's an attorney who sits 2 counties away and is just going click, 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 can't do much. But when you list with a trustee, you have a duty to say to them, and also where the executor is the oldest daughter or something, hey, what do you know about the house? We probably ought to have you do this SPQ and you can't do this. And give us as much information as you can. Very few people ever wind up in court for disclosing something. They may not make the sale, but it's better to not make the sale today and make it tomorrow than to be in court in 5 years. There is no such thing as too much disclosure. One of the things that you need to think about also is that there can be, under certain circumstances, a power of attorney given to an individual, most often somebody who will be a successor trustee, while the original trustees are still alive, or one of them is. Dad died 10 years ago, Mom is 85 and really not doing too well, but everything's still in the trust, and they want to keep it that way because who wants to pay lawyers to go through probate? Sorry. And all of our experience is we need, in that circumstance, we would if it weren't a trust, we need somebody with a power of attorney. Someone may act as attorney, in fact, for a trust. If they do that, you need to see what the authority is. Now, does the trust allow that? Most trusts do. Is this the person? Was Mom, even though she was alive and a trustee, sufficiently compos mentis to allow that knowingly, to volitionally permit somebody else to do it? We had something from a title company yesterday. Property's being sold. Back in the 90s, the fellow who's now 72 or 3 was addicted to prescription drugs. His family put him in a conservatorship, which was removed in the year 2000. We have a power of attorney that is about a year old, a durable power of attorney. He's not quite himself anymore. And the title company looked and said, hey, this guy was in some kind of custodial care, he was in conservatorship or something. We want a doctor to say he was competent to sign that power of attorney. I don't know what the hell we're going to do. I don't want to see them go back to court and get a conservatorship and spend thousands of dollars in attorney's fees. But these people are playing real games, and they know what they're doing, and they're not in it to be fleeced. So, get as much as you can on paper from anybody, a trustee, an executor, and if you possibly can get an REO to do it, get them to do the natural hazard disclosure. And remember, the family trust is being sold by the trust. not by the individual trustee. Now we have following here three things. I think we have a trust advisory listing, an REO advisory listing, and a probate advisory listing. And we can just go lump right through those by saying that they're all the same except, and I pointed out that exception before, an REO must give a certificate on the smoke detectors. Apparently people don't burn to death the first night after close of escrow in houses sold by trusts or estates, they do in REOs, which may be a true case, I don't know. Anyway, note here, exemptions, TDS, NHD, Melrose Improvement Bond Act, Supplementary Property Tax, yada yada. But down here it says they must disclose hazard zones, and they describe to a T exactly what is required on page 1 of an NHD. And if they're going to spend $24 for a one-page NHD and its explanation, they'll spend another $100 to be free of the goof, and you will get all the disclosures that your buyer is supposed to have. And at this point in my young life, I got to tell you, our policy in 3 offices that I run is, 1, you try and get the seller to pay for it. 2, you try and get the other agent to split it with you. 3, we pay for it. We do not close 1 to 4 units without an NHD. We take it right off the top. If you're on a 70-30 split, you're going to pay 70% of $125. We're just, life is too short to spend it in lawyers' offices giving depositions. This is paragraph requirements number 5. It's one of the few places where the carbon monoxide issue is addressed. There is a law in California, it has been since July 1st, last year, that all houses must be equipped with a carbon monoxide detector. All houses are supposed to be equipped with smoke detectors and with strapped water heaters, but we find them all the time that are not. Most houses do not have them. We very, very seldom have them. You might want to, on an offer, add that in paragraph 11 as one of the others, seller to equip the property with a carbon monoxide device. But note that these folk are not exempt from equipping it in that way. Now you talk to Lance and some of the gang out here, one of the first things you had to do is rush out on the rental property for your landlord and put those in. And we don't sell, I'm pretty sure we don't sell REO properties without them in there. But we have no place where it is disclosed and we have no affidavit for it yet. I suppose one will come along. Okay, paragraph 8 over here, inspection. The sale is not exempt from the broker's obligation to conduct a reasonably competent and diligent visual inspection of the accessible areas of the property and disclose to buyer material facts revealed by such an inspection in the sale of residential property containing 1 to 4 dwelling units. Brokers may do so on CAR form AVID. Do you all do an AVID? Mm-hmm. You do it on, no matter which side you represent? Mm-hmm. Good. Because when you do go to court, the first thing the judge is going to say, well, this seems to be revolved around the issue of an undisclosed item. Could I see your Form AVID? I taught a class at Citrus Valley Association. I had a broker, a managing broker, say, well, can't I rely on the listing agent's AVID? I don't know how many people he supervised, but if he's got 20 people running around saying, well, here we got the listing agent's AVID, it's suicide. One of my relatively new colleagues had a house down in Temecula. He went down there, came back, had an AVID that had about 29 items on it. His house was in reasonable shape, but it was a reasonably good thing. We also have a checklist on the AVID. We'll get to AVID pretty soon. And he handed me that, and he said, what do you make of this? And the one from the listing agent said, nothing to report on this property, written across page 1 of the, or page 2 of the AVID. And Mike had 28 items. You really want to use the listing agent?
Now, when you have a REO listing agent that's representing the bank, and because he's representing the bank, his AVID just says, like what you just said, that nothing to disclose.
That's not true.
Now, is that listing agent liable even though the bank is not?
Yes, he is. It says, and it will say it on the other one. The sale is not exempt from the broker's obligation to conduct a reasonably competent and diligent visual inspection. Now, you should go and do a reasonably competent and diligent visual inspection. And if you can do so, and you back it up with pictures, and maybe the checklist and so on, and you want to take him and have a little chat in front of a standards committee for ethics violation, not a bad idea, because he is obligated to do that. It is not an option. Whether you're getting paid a nickel if you're representing Aunt Clara, you're her agent. You have an obligation to go and see that Aunt Clara's house, or the house she proposes to buy, can be inspected, and you have an obligation to note down what you see. The rule in our office, all avids are handwritten. There are no typed avids.
Oh,
Back to the old common law, notes made at the time. I pounded a beat for 6 years as a cop. Anything that I wrote in my book which was stitched and could not have the pages removed or exchanged, anything that I wrote was admissible in court. The report I wrote from that was not admissible unless the defendant agreed to it. But my notes from a witness stand, read by me, recorded by me at the time. The same is true here. Your avid, you can use for your notes in court. I hope you don't get there. Hope you do such a good job that you don't make it. You won't go to court. What you will do is spend time in lawyers' offices giving depositions. Agency, the sale is not exempt from the obligation to provide agency relationship disclosures. Death, if the property is being sold because of the death of an occupant of the property and the buyer has less, and if the buyer has concerns about the manner, location, or details of the death, then the buyer should direct any specific questions to the seller. That is one thing that is obviated by getting the seller, the trustee, the executor, to fill out an SPQ. Since nobody is obligated to fill out an SPQ, it is a volitional form. It isn't asking them to do something that they are specifically removed from. And then you have the REO thing, which is essentially the same as far as you're concerned. You'll never have that form signed by the seller. Always get it signed by the buyer if you're selling REO. Everything you can get the buyer to sign is good. It's wonderful if you can get a seller to sign some of the things, but what difference does the SBSA, Statewide Buyer and Seller Agreement, signed by the seller make? Nothing. The disclosures are all pre-printed. They're what CAR and their lawyers consider to be the important salient facts about the state. Always have every disclosure signed by the buyer. Sometimes you get a straight sale where the seller simply will not sign. And make note of that. I'm sure you all keep phone logs, and they're detailed as to date and time and who you talk to, and after I'll take the note. Anyway, the process as you go through it is simply one of doing what is, using the tools that are given you, doing what is expected of you, not just in the eyes of the law, but with some degree of morality, and then acting on it. The seller's advisory. We've talked about the seller's advisory in the past. One of the things about the seller's advisory is that it's a marvelous marketing tool for you. If you go on a listing appointment, you take all the bells and whistles and the wonderful marketing material that you have, and here's our website, and here's the CMA that you're out, blah blah. Okay, great. Everybody does that. Some will do it better than you do. Very few agents ever take the seller's advisory, which we just think is being page 9 and 10 of the RPA, and just say, listen, before we do anything, I'd like to go through a few things that you're going to face, whether it's with me or the fellow who was just here or the lady who's coming after me. Come on, we're not very formal.
Sorry, you're recording.
Don't be silent. What, so, you're recording. It's not deathless prose, I promise you. You're going to take this form and you're going to use it as kind of a template to describe what any good real estate agent should do. And the guy who came before and the lady who comes after is probably not going to do that. They're going to say, oh yeah, well, and this is, if you just read through this, and you sign it now and you read it when you go to bed. No. We're going to enter a process. You and me and eventually some other group of people to transfer this house to somebody else. And before we get there, a lot of things that you need to know, a lot of things you're going to have to do, a lot of things you have the right to expect from me and from others, and a lot of things that you're obligated to do. Let's talk about it. I like the start out. It doesn't sound like it was written by a lawyer. Selling property in California is a process that involves many steps. From start to finish, it could take from a few weeks to many months, depending upon the condition of your property, local market condition, and other factors. Well, that's pretty non-threatening. But then the first thing you get to is disclosures. You must affirmatively disclose to the buyer in writing any and all known facts that materially affect the value and the desirability of the property. Well, that's pretty scary. Like, I don't even know what the known facts are. I've lived in my house 44 years. I can't remember what's wrong. I've lived with it so long, I'm not sure what the world's going on. So, well, look, what we're going to do here is I will work with you. I will hold your hand going through this. I can't make your disclosures. First of all, I don't know what to disclose. Secondly, I'm not allowed to. It's your transfer disclosure statement, your seller property questionnaire. What I can do is talk to you about the things that you should be looking at and thinking about and trying to remember. And I will also be making my own inspection, which I will put down on a form called the Agent's Visual Inspection Disclosure. And I will be pointing out to you things that I think probably ought to be picked up by you. You know, there is a big cracked tile, and that very large tile in the sink, and that's probably something you'd like to include when you do it. But we get down here and we talk about statutory duties and time constraints and doing things timely. When you get an offer, you're under certain time constraints. If you don't get them back, you're in breach of contract. I will see to it that you're kept on a timeline. This is your template for making a sales pitch about you. Everybody gives it out. I don't know anybody who doesn't hand this out. I don't know anybody but our gang who talks about it. It's a great selling tool. Contract terms and conditions. We have contracts that can run to 20 pages. I would be very happy to walk and talk you through all of those as we go along. There are going to be some things the government requires. I'm a little out of my territory, Auntie, but we are selling a house in the city of Los Angeles. And Los Angeles is pretty draconian. Los Angeles wants you to have sliding glass doors covered with Mylar if they aren't tempered glass. They want you to have low-flow shower heads. They want you to have low-flow toilets. And they want you to have an automatic gas shutoff valve. That's required before escrow closes, and it's going to cost you money. And I think you need to know that. And I'll help you through it. I'll provide you with vendors who will do that for you. Your house is old. I noticed that the fascia board has been recently repainted, getting ready to sell the house. That's good to do. But how was it done? Did somebody come along and just fill in the cracks and paint it? Okay. But that's the original fascia board, isn't it? Well, did somebody come along and take a grinder to it? Yeah, and the house was first painted in 1950, and again in 1958, and again in 1968, and again in 1976. There's probably 4 layers of lead paint. There are rules about how those things are being done now. You have to have people who are certified. If it wasn't done, too late now, we aren't going to go back and unpaint it. But when it comes time to discuss lead-based paint remediation, you're going to have to say it was done but without remediation. It's not a sin, and the federal government isn't going to come and poke their finger in your eye. But if the buyer gets wind of it later on and comes back with a problem, and you didn't say so, you got a problem. So, I'm going to help you through each of these stages. Pre-marketing, you consider doing, here's a nice one. We used to have to go and say, oh my God, how am I going to tell this place looks like badgers live here? Well, you should consider doing what you can to prepare your property for sale, such as correcting any defects. Many people are not aware of defects. And oh my God, why don't you ever wash your dishes and make the beds? You've been to places like that. Post-sale protection. This is where you slip it to them about home protection plans. What's the rule on a home protection plan? What do you tell the seller about it? At listing, at the seller. What do you tell the seller about it at the time of listing?
Well, it's a good selling tool for their property.
True. What other obligation do you have? Do you have an affirmative duty, say, Mr. and Mrs. Seller? For 72 cents a day, this home protection company will cover some of your appliances and utilities for the entire listing period and the entire escrow period, and it only gets paid if escrow closes and you have protection all that time. Would you like that protection? Sign here. No, sign here. What happens when we get up to day 44 and the bottom falls out of the water heater? And they later learn that you didn't tell them that they could have, well, water heater replaced for zero, guess who's gonna replace it? It's the only way I've ever found to really teach people to present a home protection plan as a seller device. I presume you all do the same things with title reports, right? With title insurance. You tell your buyer, look, there's 3 or 4 levels of title insurance. We're asking for the middle range, but you can pay some more and get more protection. How many of you tell them that? About the same number. So tell the seller about home protection plans. All these are really risk management tools. It protects you, and always make them sign. If they say, no, we don't want that protection, make them sign, but don't tear that part off of the contract. They'll sign where it says no, keep the whole contract. This is what we're saying no to. And stick it in your file. 9,999 times, nothing will ever come of it. It's the one time, and you don't know which one that is. It's going to grab you, and you'll find yourself replacing a water heater or something. Safety precautions. Well, that means put away your jewelry, put away your cameras, put away your this, put away your that. What must you really urge them to put away in this day and age?
Their prescription.
Prescription drugs. Prescription drugs.
This is
They're the
on
largest single item stolen from houses
Hey, girl.
that are listed. Okay, here's our listing agreement. Does anybody need to take a break? Because we have about a half hour to go.
I'm sorry,
Yeah, go
I have
ahead.
a quick question. This was back on the agency.
Yeah.
In your practice, how often do you see the broker rep agreement used and signed?
Broker buyer?
Broker representation agreement.
Yeah.
Hey, you and me are gonna work for this amount of time.
Uh,
Is that often, or is that pretty much phasing out, or in this marketplace? What's your opinion on that?
My opinion on that is we all ought to do it. We're all of us afraid to do it because the guy down the street won't.
Right.
It's run along about the same amount all through my years, about 3%. The most successful agents do it. New people do it because they don't know any better. And people say, oh yeah, fine.
Right.
They don't know they can't. I think it's a great thing. If you think about the licensed professions, doctors, lawyers, any of them who do 5% of their time pro bono, considered saints in their industry. We are licensed. I think we are hardly a profession. We do 50% of our work pro bono, sometimes more. We give away more of the only commodity we'll never get back than any other industry in the world. Time.
Absolutely.
Time. You get up to my age and I tell you, it looks very important. So what you want to do is, if you can pull it off, do it. And don't make it unreasonable. Don't say for 120 days. Well, no, that's kind of silly. If you can't find what they need in 30 days, or at the most 45, either you're not trying or they're really serious lookers and not serious buyers. Because the whole purpose of it is they just have that impulse on this one Sunday you take off to run out and look at an open house and buy it from that guy. If you buy it from that guy, you're going to pay me a commission. And of course, if the time comes, you're not going to demand 3% of the $400,000 new house that they put up. But you are going to have some standing. I think it's a great idea. You can't sell a house without a contract. You can't list a house without a contract. You can't do anything in real estate without a contract except represent a buyer. Yeah, it's a good question. I like questions like that.
I think, Norm, that most agents are afraid to use that in fear that they might lose that client.
Yes, exactly.
That's the reason.
Exactly. As I say, the best agents, the ones who are most confident and have the largest book of business, are not afraid. No. Look, I have only one thing to give you, and that is my brains, my experience, and my time. You want to pay me up front to show you houses, I'll be glad to accept that. $50 a house or $200 for an afternoon. Or you agree that you don't pay me anything, but when you find a house, I get paid. I'll show you all the houses you need to see. But it's a very tough concept. You know, there are people sitting in this room who would never think of doing it because the next person sitting next to them won't. And it's a question of guts ball. And sooner or later, we'll reach that point. Sooner or later, we'll reach fee for service. We'll reach $50 a house or $200 for the afternoon. We'll reach we'll reach $850 to list your house, put it in the MLS and market
Your
it.
mouth's God's ear.
Okay.
Yeah, no, it will happen. It probably won't happen in my life. You'll all be W-2 employees too. Oh, yeah. State of California is really pushing that. They want our money now. Okay, residential listing agreement. 2 or 3 things that are important. Residential listing agreement is not valid if it does not have an ending date. It just is not a legal contract. The other thing is, if you go tonight and they say, oh, we'll take the listing, we'll give you the listing, but we want about 10 days to clean this place up, don't say, okay, I'll just date it 10 days from now. Date it tonight and get them to sign the form that says permission to keep it out of the MLS. And why? Well, one of my colleagues, senior agent at the Covina office about 4 years ago, went and did just that. He went, listed the house, old-time friends. They listed it, they said, Walter, we'd very much like to just have about 10 days. We want to recarpet, paint the interior, maybe do the trim. Would that be okay? Oh, sure. So he listed the thing for 10 days later. And about 4 days into the 10 days, some bright young feller's driving along with these buyers, and he drives by and he looks and he says, hey, you like this neighborhood? You see the carpets out there, and there's a guy painting the trim, and there's somebody going in and out. Just give me a minute. He runs inside, he says, knock, knock, Mr. and Mrs. Seller. Are you preparing the house for sale? I see all this going, oh yeah, we are. Well, I have buyers. Would it be okay if I show them? Well, it doesn't look very good. Yeah, but they're right in the car. Can I just walk them through? Get through? They said, we'll take it. And so he said, show me your listing agreement, I'll contact your agent. And he looked at the listing agreement, and bright lad, he looked and said, you don't have an agreement with anybody. This doesn't take place for another 6 days. It's like a post-dated check. And he said, I'll represent you both, and I'll charge you 4%. And the seller said, to hell with Walter, we'll do it. And Walter lost everything, and this guy got 4% commission. All legal, ethical. You know, ethics can be a movable feast in this business. Would I have done that way? No, probably not, but then I'm old. I think that there is something to be said for doing it correctly. List it today. If they want it kept out a month, we'll just fill in the form that says, keep this out of the MLS for a month. But if a bright young boy comes along and sees painting and carpeting and so on, and goes in and sells it, you get the commission.
Now, when you say leave it out of the MLS, do you still put it in, but you just put it on hold?
No,
Or do you
you
not
can't put it in.
at
No,
all?
it is not. You have to tell the MLS that it exists, and you have to show them the form that says, keep it out until April 25th or something. No, don't put it in. Not listed is not listed is not listed.
You said show the MLS.
Hmm?
You said show the MLS, but.
Yeah, you have to show the
The
board, you have to show your
association.
association
Yes, right.
that you have this form.
Okay,
I mean, you can't just keep it out on your own, you've got to have it in 48 hours.
okay.
Or they scream and dance around and carry on.
Stay in my form.
Not that I see.
There's
Okay,
a form.
Okay.
it's here somewhere, we'll come to it. I can't remember the sequence, we altered this. This is the 3rd change since I was here the last time.
Oh, wow.
It's just, it's amazing how much has changed. Anyway, paragraph 2, items included and excluded. Why do we put this in here? Because that's what they want included and excluded. What force and effect does it have?
Don't you have to also put it in the MLS?
You
for it to
bet
be-
you put it in the MLS and, in addition to the MLS? Who's this a contract with? The seller and?
The broker.
Right. What do we care? Can we enforce that against them? We're not buying the property. Who can enforce taking away something or demand the return of something?
The buyer.
The buyer, of course.
Oh,
So,
okay.
you put it in here and you put it in the MLS, you might as well not put anything. If you don't have it in the contract.
Yes, okay.
If it's not in the contract and it's attached, it stays. We've had a few hair pulling contests over that. This is a moral club that you can use at the time that you get an offer. To say, hey, wait a minute, you promised and we advertised and, well, you can't do that to us. And they say, yeah, we can, because it doesn't, yeah, we're just gonna tell, we're gonna tell a buyer no. But if you don't put it in the MLS, the world will not come to an end, except you'll have an angry broker at the other end, because he, well, you know, we thought maybe that was included. You know, the $850,000 carpet, or the, you know, the Tiffany chandelier that grandfather brought back from the Paris exhibition of '92, that's 1892, well, we thought it was included. But if you don't have it in the contract that it's excluded, you will have a really angry seller. This is information for us. These are tools. We're going to take the chandelier out. We're going to urge them to get the chandelier gone before we get the thing on the market more than a week. Take it down, put something back that is, you know, represents the living room or the dining room, wherever it's supposed to be. And we'll be sure to clean up the washer dryer, because we're going to advertise it's included. So when you've done that, then you are informed, and you have the opportunity then to put that in the MLS as a sort of gimme. Can you put that on Craigslist? Washer and dryer included? Sure, no reason why not. Anything that's advertised is only advertised. It's when it gets down to buyer and seller agreeing. And if the buyer and seller can't agree, that's when your negotiating skills come in. But suppose we put down washer, dryer included, and then at the last minute, daughter who's just gotten married, because she had to, and her ne'er-do-well husband say, hey, look, we don't have a dryer, never had, and the washer that we have is an old Ringer, can we have the washer and dryer? And mom and dad say yes. And you're advertising washer and dryer included without warranty. Where are you? Doesn't matter. If the seller doesn't want to do it, the seller doesn't have to, because it is between the buyer and seller that that ultimately comes home to roost. The listing price, I'm not going to tell you how to derive that, but when you put the listing price down, just remember what your CMA said. And if it's different, we're going to talk about that when we get along. Additional terms. There are a lot of people, mostly older, whose houses are owned free and clear. And they would be very happy to have a little extra income, and they might be happy to get a little higher price for their house if they could. And one way to do that is to have some form of seller financing. What's the rule on PMI? There is none if the loan to value is only 80%. So if Mr. and Mrs. Buyer have 15% down and the seller is prepared to carry 5%, they can get 80% LTV first, and they don't pay PMI. And that's often very favorable to the seller, because maybe they get a little higher price, but they also get the income on it for 5 or 7 years. And maybe they'll even be a little, if it's large enough and it's spread over a number of years, they might get some tax deferment on capital gains, if there is any. In this day and age, that's a bit of a stretch, but there might be, because the money's received over a period of time. Seller will consider carrying a small second trust deed. It doesn't say seller will carry, it says seller will consider. It doesn't say how much, it says small. To me, small is anything that's less than 20%. To some places, some people buy 5% down, 80% bank, and 15% seller. Of course, happens all the time. There's a separate form for that, which we can talk about.
So what happens when you have a seller that does own the house free and clear, but they don't want to go based on the CMA, they actually want to go lower because they want to get rid of it? Is there anything we need to do to protect ourselves that,
Yeah, when we get to I think paragraph 18 is where we touch on that. It's usually the other way, they usually want to list higher. You'll notice that the largest single section in this document is devoted to our compensation. Okay. I put 6% down there just because it's 6%, and that's the usual flag. To me, the most important thing on there is paragraph D. What are you giving to the outside broker? Now, I've never understood why the commissioner does not insist that that be done. I insist that it be done. I don't accept offers, I don't accept listings as correct unless that is put in there. Our rule of thumb is 50%. If it's less than 5% total, then we take 2% and give 2.5% to the outside broker. But it is stipulated here, because the seller is giving that money, is entitled to know, I'm keeping 5% and I'm offering 1% to anybody who's stupid enough to come in here and sell your house for 1%. Well, that's not a very good selling proposition. So I want it there. We very seldom get tangled in other brokers. Be sure that if you have something that's been listed previously, it has an unconditional cancellation attached to it and shows canceled in the MLS. Not withdrawn, not withheld, not on hold, whatever it is. It is canceled. Kaboom. And be sure and see the cancellation. Ownership, title, and authority. This is paragraph 5 on page 2. The seller is the owner of the property. No other persons or entities have title to the property. Well, we have had recently some rather interesting things. Folks who, after 20 years and a lot of economic battering, have finally reached the point where they can afford to move up. They have some equity and they want a little different house. And it turns out that when they bought the house, Mom and Dad came in, signed on, and the bank wouldn't let them sign on the loan unless they were on title. And now Dad is dead and Mom's living in Taipei. It happens. Learn that way up front. We have ways to get around that without any difficulty whatsoever. If we know. The best way to do it, of course, is we always had pulled property profiles, but most title companies now, because it's so cheap to do it over the internet, most title companies will give you a preliminary title report and see if there's anybody on there. Always be sure that the person who is signing is at least one of the people who is on title. You can take a listing from one person, put it in the MLS and sell it. You can't close escrow unless the other people on title sign not just the escrow instructions in the purchase contract, but also sign the listing agreement. But you can put it in the MLS based on one signature. But be sure the signature belongs there. Well, I never recorded the deed. My dad gave it to me just before he died, and I have this unrecorded deed. Well, let's take a look. Was Dad there? Is Dad's name on the deed? Is Dad's name on the current title report? You take reasonable precautions about that. Multiple listing service. We're telling everybody, we're putting in the MLS unless you tell us not to. If you tell us not to, you have to sign here. We're going to put it on the internet. Why is it important to say that? Well, other brokers see it on the internet. Buyers see it on the internet. Other internet servicers or search engines see it on the internet, and burglars see it on the internet. So we put you on there with this wonderful video tour, and they see the Picasso or the Tiffany lamp. Hey, let's wait until they've gone to church on Sunday morning, see what we can do. Happens. So we tell them about that. Now here, paragraph 7, very important in this era. Seller represents that unless otherwise specified in writing, seller is unaware of 1, any notice of default recorded against the property, 2, any delinquent amounts due under any loan secured by or other obligations affecting the property, or 3, any bankruptcy, insolvency, or similar proceedings, etc., etc. Don't have your client put pen to paper that tells a falsehood. You don't know where this is going to wind up. So, notice of default, well, over here we'll just put down here in paragraph, I think it's 18, or 17. Paragraph 17 would say, under notice of default recorded and put the date. Or seller file bankruptcy. You don't really want a property in bankruptcy, so let's put there. Broker, and here's, we talk about contracts, and I didn't mention this at the beginning, I'm sorry. The contract, again, contract law is very clear. Lawful intent. It's lawful to sell a house, buy it. Mutuality. I agree and you agree to exactly the same thing. And consideration. And people come kind of stuck when I say, what's the consideration in this? And they say, well, the commission. Well, no, this has nothing to do with commission. They may never sell. What consideration is offered us and provided to us by the seller? Answer, the right to exploit the house. The right to come in and do open houses, to show the thing, to advertise it, to make every effort we can to sell the property so we may then get real money. And what is our consideration? It's contained in paragraph 7, the very first line. I'm sorry, paragraph 8, the very first line. Broker agrees to exercise reasonable effort and due diligence to achieve the purposes of this agreement. That's it. We'll use our brains and our history and our knowledge of the neighborhood, and we'll do our very best to sell your house. A somewhat different standard applied in, say, mid-2005 and applies in mid-2012, because you have to do a great deal more. But that's all we have agreed to do. Reasonable effort and due diligence. And sometimes people wondered at what point or how the buyer's deposit becomes the broker's property, and the answer is down here. As soon as we get an accepted offer, the right to maintain custody of that money is transferred to the broker, and by the extension to the selling broker, who probably will keep it till escrow is opened and then endorse it straight to escrow. The property includes residential property with 1 to 4 dwelling units. This is 10, a disclosure of agency. Seller representation, broker shall represent the seller in any resulting transaction. Possible dual agency, we say, hey, we might be here working both sides of the street. We may work other sellers. We may get an offer from the guy across the street to come list his property after he sees what a bang-up job we do on your first open house. We're all permitted to do that. You don't want that? Gee, I don't know, maybe, you know, that doesn't sound fair to me. It's how I make my living. Part of how I make my living is to do a great job for you. If I do it for him, he'll be happy, you'll be happy. And of course, what happens is, you have one open house, you list the guy's house across the street, you come back with a second open house, it's in escrow, and this one has had no offers on it. Security and insurance. You're not responsible. Key safe, we come to the key safe individually. The key safe is a very important element to our work, but you cannot put it on unless everybody who is 18 years or older and in the house has signed a key safe agreement. I'm not comfortable with people who don't want a key safe and don't want to sign and don't want it in the MLS. You're not going to sell that. You know, spend your time on something else. Equal housing opportunity. It's been so long since I've seen an issue. You know, 30 years ago when I came in the business, color was an issue. Religion was an issue. And we fought and we fought, and I think we finally won. I have not seen any clear evidence. I haven't even seen fragmentary evidence of any kind of non-equal housing. I mean, look around the office. We look like the United Nations. It's a non-starter. It's just people don't think of it. Successors and assigns. This agreement shall be binding upon the seller and the seller's successors and assigns. Oh, gee, I'm sorry, Mr. Jones. I understand your mom died last night. Well, we're having an open house here too. Would you mind getting the body and yourself out of here? Oh, well, you're obligated to. It says so right there. Oh, didn't your mother's signature mean anything to you? Are you going to do that? I don't think so. I don't think so. It may be they want you to, but you're not going to enforce it. And be sure that you include on 17 any of the forms, and then seller is related to listing agent. Very important. And here's where you would put, at the time of listing, agent's opinion of price was, and you should do it whether they want to list for more than you believe it's worth or less.
Oh, okay.
Because if you put it more than you think it's worth, and they just keep following down, they reduce it $10,000 a time, and every time they do it's where it should have been 2 changes ago. And then they say, well, 6 months later, we're suing you because you made us listed at this. What evidence do you have to the contrary that you didn't? If you put on here, at the time of listing, and what we say this was 365, at the time of listing, broker's opinion of price was $325,000 to $5,000. You have a leg to stand on. The same would be true. It's not a sin. You can get in and give away their house if they want to. But if you've got your name on it and you're selling it below market, and they come back and say, well, they made me sell it for $245,000, and you say, well, at the time of listing, broker's opinion price was $275,000 to $295,000. Very difficult to do anything. Mediation, paragraph 20, that applies whether or not the arbitration provision is initialed. Oh, always do mediation, mediate. I'm gonna get you out of there very close to on time. Okay, let's take a look at the arbitration. You may say this, not as a legal opinion, but as something told to you. It may be a form of hearsay, but it is true. Your instructing broker, your CAR certified instructing broker, told you that in the 30 years he has been in business, and the 20 years since arbitration has been part of the contract, he has never met an attorney who would allow his or her client to initial arbitration if that attorney was asked. That's the extent of what you can tell them about whether or not they should initial arbitration. As far as the law is concerned, go talk to your attorney. As a practical matter, if you're doing a short sale or an REO, it is very unlikely that that forgiving bank or that the selling bank is going to accept an offer that does not have arbitration initial. It then becomes an issue for the buyer to decide. There is nothing in the book that says that you need to pay attention to your attorney's advice. But if you just tell them, your attorney probably will tell you not to do this, but you should ask him. You've done everything that you're required. Now here's the real thing, down here in this big notice and big thing. You are giving up any rights you might possess to have the dispute litigated in a court or jury trial, and there's no appeal. Now here's this form we were just discussing a few moments ago, the SEL, instructions to exclude the listing. Are there good reasons why you might want a property sold and pushed like the very devil, but you don't want it in multiple listing service? There are a few good ones, I suppose. Real illness in the family where it has to be your word and your clients maybe. But if you don't put it in multiple listing service, where are you going to put it? You know, we don't advertise anymore. How long has it been since you looked at, what is it, the Riverside? What is that? Press Enterprise.
Press Enterprise.
Yeah. Some of you have been in business long enough to remember when the semi-section real estate was huge. It's nothing now. It's all online, and most of the stuff that's online gets there through the MLS. It's one of the really good things that they've done. They put it up on a variety of sites. We figure between 40 and 50 sites are populated from that one MLS listing, and of course we put it on Craigslist and all that stuff. But the likelihood of selling in this day and age without a cooperating broker is pretty small. So they need to have a very good reason to leave it out, and then you need to be convinced that it's worthwhile for you. So remember, you're not obligated to take this listing. So what you need to do is think about it. It gives you all the reasons why it's good to belong to the MLS. It gives you all of the reasons why it is our recommendation that they belong. And then it says we want to opt out of some things. If you go to page 2, paragraph 5, they want to exclude the property from the internet. And they exclude the property address from the internet. They want to exclude in paragraph 6 comment or property review features. Exclusion of automated estimates of property. I've talked with the association, CVA, they're pretty alert. I think they have a very good handle on how the world is working. None of them can really assure me that if we put it in the MLS, that we can keep it there. That's the downside of all this. In fairness, I have not had, or known that my colleagues have had, I should say, any seller ask that it be excluded. So maybe it's, well, maybe it's a fig leaf to throw to people. Would I take a listing in which any of these were excluded? I'd have to be pretty confident I could make it work and pretty hungry. Because I could not, in conscience, tell them if we put it in the MLS, this won't happen, so I'm going to have to ask you to exclude it from the MLS entirely. I'm not sure that that's good agentry, and I'm pretty sure it's not good business. And I think the chances of your unloading it pretty small. Put a sign out and pray would be my idea. Okay, the real estate transfer disclosure statement, and then ta-da, we're finished very close to on time. Actually a little ahead of time. These new programs are gonna be 2 hours apiece, so you only have 6 of them to come to. All right, the real estate transfer disclosure statement. Rule 1, your handwriting or your typewriter should not appear below the line that says 123 Elm Street, San Pasquale, described as. It's okay if you're fairly confident that they will do the TDS while you're with them this afternoon to put in the date, and there you stop till you get over to paragraph 3 on page 3. This is a snapshot of the property through the eyes of the seller. And that is true whether the seller lives in Washington and has not seen the property in 6 months and never lived there. They are required by law to provide this. You are required by law to get it. This all started with a very interesting case. Most of you are familiar with it. Can't remember the name. I remember Starker, which is the exchange. Anyway, not important. The buyer bought the house, saw it at night with an out-of-county agent, wrote the offer, got accepted, got closed, moved in, and 2 months later the house just sort of drifted down the hill. And the seller, the buyer then said, well, I noticed after I saw this in daylight that there was a very large netting made of very heavy nylon cable stretched up the hill behind it. And I didn't know what it was for, but I now realize that there was some prior movement of the earth and that the seller had put it there to retain the wall. Easton versus Strasburger, I knew we'd come back to it. Anyway, he went to the trial court, and the trial court said, do you ever read any of these things, counselor? It says, buyer beware. The buyer is responsible for all of this. There's nothing on the statute that says the seller has to tell you anything. There's nothing in the rules that say the seller has to tell you anything. And out. Well, this guy was kind of determined, and so he went to the Superior Court. In those days, the trial court was municipal. He went to the Superior Court. The Superior Court said, out. Buyer beware, caveat emptor. He went to the Appellate Court of California, and they said, do you ever hear of caveat emptor, counselor? Out. They went to the Supreme Court of California, and they came out with a ruling almost immediately, and the ruling started out as, we're not sure why we are looking at this case because the requirement that the seller and the seller's agent disclose what is known about the property has been on the statute book since 1870. Oh my God, those of us who are practicing mental health, the world has come to an end. For 100 years, we haven't been doing what we're supposed to. My God, what are we going to do? Now we all have to be home inspectors. Well, very cleverly and quickly, this thing came up, which is very weak, which is why we have the SPQ. I would like to see the SPQ substituted for the TDS. This is statutory. The SPQ is volitional. But we did manage, all of a sudden, litigation against real estate agents went from here to here. In 2 years' time. Because the seller was forced to say things that previously the agent had to ferret out. There was no demand that the seller tell anything. The seller just sat on his hands, waited till escrow closed, and then the buyer sued the real estate agent. Well, this was the first step of emancipating real estate agents from liability for undisclosed issues. And this has been with us now for very close to 30 years. It came along shortly after I got in business. The thing that is important is when you're giving advice about this, and remember, you'll hear me say it a number of times in these gatherings, we are now by court mandate counselors and advisors. We are not just negotiators and facilitators and showers of property and scribes that write things up on documents. We are counselors and advisors, and part of your task is to counsel people to take care in answering these, to answer them honestly. And then you get questions, well, gee, we're going to take the stove with us. Yeah, but that isn't the question. The question, was there a stove in a place the day you did this? Yes. Then you mark stove. Oven, range, whatever it happens to be. Yeah, there's one there. Why would we do that? Because we're taking, no, this is not a contractual document. This describes the property to a buyer. On the day that you did this, you put the date on there. If we have an earthquake, a lot of us had a lot of changing to do to TDSs, or our clients did. after any listing taken on the night of the 16th of January of 1994 had to be radically changed by the morning of the 17th, because that's when all of the northern San Fernando Valley came to bids. Substitute disclosures, additional inspection reports, anything that has been previously created. It's all right, keep coming. Don't worry about it. The only thing that you have to be sure of is that these people understand that if they have the house in escrow 6 months ago, and there was a report, a professional inspection done and a report made, they must include that with this form for the buyer. Any of those things must be included. And they must answer these honestly. Now, this is the only place where there is any indication that the seller is even aware of carbon monoxide, and down there it says, is there or isn't there a carbon monoxide device? Not really cool. There's a lot of opportunity for error on this, and one of the things that you have a responsibility to do in completing your audit is to be sure the palpable, observable errors that they have made here are corrected. Paragraph B on page 2, are you, the seller, aware of any significant defects, malfunctions in any of the following? Interior walls, ceiling floors, exterior walls, insulation, roofs, windows, doors, foundations, slabs, driveways, sidewalks, walls, fences, electrical systems, plumbing, sewer, septics, and other structural components. Do you think you can't walk through a house and find something wrong with some of those? They better be pretty specific. They better say there's a crack in the ceiling in the kitchen. And over here where we have on paragraph C, yes or no answers, you'd be surprised how many people live in condominiums or planned unit developments who say there's no overarching authority, no homeowners association, no CC&Rs. Be sure and read these. Ask them if they want to correct it, and if they will not, you must do it absolutely on your avid. Let's go all the way down to the bottom here, paragraphs 1 and 2 at the bottom of the page. The seller certifies that the property is at the close of escrow will be in compliance with section 113.8 of the Health and Safety Code by having operable smoke detectors which are approved, blah, 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 blah. And also the same thing, number 2, water heater strapping. Is that a requirement of the contract when we get to the RPA? Is this document a disclosure or a contractual document? This document is a disclosure, and they put a contractual item down there at the bottom, shame on CAR. They can check them if they want to, but make them do the real disclosure that is part of the contract. We've already said this only describes the house on the day, etc. And what is that? That's informational. A buyer can't come back and say, hey, you checked that there was a range and oven on there. Yeah. But it was a freestanding range and oven, and we took it with us. Well, you put it in. No, this is not a contractual document. This is an informational document. This is a disclosure. I think this is very, very dangerous. And I suspect somebody somewhere is going to do a test case on it. And then over here, paragraph Roman 3, agent's inspection and disclosure, or paragraph Roman 4, which is for the selling agent. Here is where the only thing you do is check the box that says, see attached agent visual inspection disclosure. You do not check agent notes no items for disclosure, or agent notes the following items, because there's not enough space there to do a decent job that you will do with the Avid. Mark the box that says the attached Avid form, and you're home and dry. Okay, key safe, lockbox, last form. Very important form. 1983 or 4. I happened to be in the jurisdiction where I was working there, Westlake Village. Kid came home from college, brought his huge, underpowered, under-memoried PC, and put it up in his room. Put up this huge monitor, plugged it all in, about $10,000 in value. House was up for sale, had a key safe on it. That was the days where we had a key and it twisted it and it encoded. You had a code on a key and it impressed it on a Mylar. And we took it off couldn't find it because they went to a party, Christmas party at the neighbors, came back, the computer was gone. And the dad said, hey, wait a minute, $10,000 is a lot of money. But I ended up putting a kid through school where I have to pay $4,000 or $5,000 a year to put him all the way through college. On a $10,000 computer, which you, now, if you could get one that bad now, would cost you $200. I want restitution, and the broker said, look, read the part where it says we can put a key safe on there. We don't carry insurance for this, it's not our responsibility. You have no claim. So he went to the trial court. The trial court said, hey, dummy lawyer, did you ever hear of a contract? Did you ever read what it said? It says the seller's responsible for security. The broker's not responsible. And they went to the appellate court, and the appellate court said, don't you read the contract you signed? And went to the state Supreme Court, and the Supreme Court said, we have but one question. What was the age of the young man who owned the computer? He was 19. He said, anybody 18 or older is emancipated in this state and has the right to decide who will come onto the property. If you have somebody 18 or older who is not on title and who did not sign the listing agreement, if you do not get one of these and the place is ripped off of their stuff, you're stuck. If grandma and grandpa come to visit for 2 weeks at Easter, either take the key safe off and say so in the MLS, or get grandma and grandpa to sign one of these. If you are listing when Sonny is 17, and that'll be in 2 months, and you have a 90-day listing, you better show up in 60 days and get this signed by Sonny, because otherwise you're liable. And the most important place, of course, is in tenant-occupied property. And one of the reasons why a tenant-occupied property, even single-family, you so often see, make offers subject to interior inspection. Because you don't know who's there. You may have mom and dad and an 18-year-old on there, but the 18-year-old's girlfriend is living there, and the 20-year-old daughter comes home. You have no way of knowing who's there. It's really tough on rental property when you're trying to list and sell. Use this form, don't be shy of it, and explain to mom and dad, or whoever it is, if I don't get those signatures, and they're 18 or older, I cannot put a key safe on there, and I'm cutting the likelihood of selling that property in half. That's a good statistic, by the way. You've got a neighborhood with 5 safe for sale, and 4 have key safes and 1 do not. It will be shown probably 50% or less at the time, at the other time. Okay, we will meet here 2 weeks from today. Today is the 4th and 14th, it must be about the 18th. Be about the same duration. Do you have any questions? Is there anything that you want to talk about?
Yes, Norm, under the, where it says the agency, see attached avid inspection.
Yes.
Should you also write, as we used to in the past and still do, that the selling agent should, the buyer should also have an inspection done?
Do you know what that says to me if I'm sitting up at a bench or in the jury box? Well, I've read the contract, I've seen all the disclosures made to the buyer. Attorneys have said that 6 different places in much better language. Why did you think it necessary to second guess the attorney? Didn't you do a good job? Never put it in.
Never put that in, just.
I've heard it used against people in
use
court.
the attached.
Why did you put that in? The attorneys are paid to put that in there, and the buyer has signed it everywhere else. Why would you, on an advisory from the seller, tell them to do something the attorney said so much better? It suggests to me that you were not entirely sure what you did. Did you make a good, is that a real avid, or did you just make that up? No. Stand on what you have. Did you do the inspection? Yes. Did you do it to the best of your ability? Yes. Is his requirement to do it to the best of his ability different than mine? Yes. God help me if I miss something on an avid. One of the reasons I don't list and sell is because I have such a high standard of care.
Well, what's that have to do with a buyer having a home inspection? I mean, that's what you and the listing agent and the selling agent did, but you're trying to protect yourself to make sure that.
How does
the
it
buyer-
protect you to say the lawyers don't know what they're talking about, and I'm not so sure about myself either? I don't see the protection in that.
That you're recommending that the
You're
buyer.
recommending that
have a
you're recommending that they take your one line and put that up against 7 different disclosures now that the lawyers have made. and you think you're doing it better. What is your reason for giving that advice? You're not telling them you have to have an inspection, which one place says if you do it, don't do it, you're doing it against the broker's advice. You're not saying buyer and seller are recommended to get tax and legal advice before proceeding with this transaction anywhere. Why would you do that? The one thing for which you have a specific responsibility, which is to look, to see, and write down, why are you calling into question that one thing when the lawyer's done all the rest?
Okay.
How does it hurt to leave it out? It said, you know, they've signed it all over the place.